Welcome back to Lost Dash Channel. My name is Anton Vieltsin. I'm an attorney in the Southern District of California here in San Diego. I'm actually licensed in California, Nevada, and I take cases throughout the West Coast. Today we're going to discuss a Ninth Circuit case where police officers were dispatched to a Lowe's home improvement parking lot where a box truck was parked and the caller said that there was something suspicious about the truck. The officers arrived, opened the back of the truck, and found marijuana. Of course, the question is going to be whether that was going to be a legal search under the Fourth Amendment. But before we answer that question, I want to thank you for watching me on YouTube. Please subscribe there. And if you're listening to the podcast version on Spotify or Audible, please follow me and give my podcast a 5-star review rating. Now, with the help of my legal expert, Carrot Top, we're going to discuss this case after this short break.
Hello, this is a prepaid collect call from
Lost Dash Law Firm
at Western Region, San Diego. To accept this call, press 5. To refuse this call, hang up now. Thank you for using T-Netics. You may start the conversation now.
We have two major problems. Number one, it turns out Carrot Top is not a legal expert. And number two, I couldn't get him on this show. So if you have connections and if you know who he is, I'd love to speak to him and get him on this podcast. But for now, you're stuck with me discussing United States versus Yuen, which is a Ninth Circuit case dealing with the Fourth Amendment. You already know a little bit about the case. Officers were dispatched to a Lowe's parking lot after a caller told the police that there was a suspicious box truck parked at that parking lot. Now, the individual also said on the phone call that he saw a person get out of the cab, walk around the truck, and get into the cargo area of that truck. 2 police officers were dispatched to the scene. When they arrived, they could hear that somebody was in the cargo area of the truck and what sounded like a drill. The officers walked around the truck and the back door was slightly open. The officer kneeled down, tried to look inside, but couldn't really see anything inside the truck. So at that point, he simply decided to roll up the door all the way up. Now, once the door was open, he saw Mr. Yuen, and the officer later testified that he could smell marijuana and see a bag of marijuana close to the back wall, that false wall behind the cargo area and the cab. Now, Mr. Yuen files a Fourth Amendment suppression motion saying that this is a violation of the Fourth Amendment. Remember, the Fourth Amendment protects you against unreasonable searches and seizures. And if officers don't have a warrant, and if none of the exceptions to the warrant apply, that would be a per se unreasonable search and a violation of the Fourth Amendment. Now, the first question here is whether this is a search. Of course, this is a search. Anytime officers or any law enforcement goes through an area, let's say from outside to inside the building, from outside a container to inside a container, anytime they go through a barrier, that could be deemed a search. And of course here, opening that door to the truck is in fact a search because they went from the outside and now they can look inside the truck. Now, we need to look whether any of the exceptions to the warrant requirement applies. First, the automobile exception. Under this exception, officers can search inside the vehicle without a warrant if they have probable cause to believe that incriminating evidence will be found inside the vehicle. And the idea behind this exception is that vehicles, by their nature, are mobile and people have less expectation of privacy in their cars. Whether you believe that or not, that's what the Supreme Court says. Now here, there is no probable cause that any incriminating evidence would be found inside the vehicle. Why would there be? The caller said that this was a suspicious truck, but there was nothing else that was told to the officers about the nature of the truck or anything inside the truck. So when they're walking around it, that's legal, but once they're inside, Well, there is no probable cause saying that something incriminating inside of the truck would be there. Now, the second thing would be the Terry search. If police officers believe that an individual is armed and dangerous, they can pad the outside of the clothing, and of course they can look inside the vehicle if they believe that weapons would be found there. But here, the Ninth Circuit says, again, there is no evidence that Mr. Yuen is dangerous, and there's also no evidence that there would be weapons inside the truck. For these reasons, this is in fact a violation of the Fourth Amendment, and all fruits of the search must be suppressed, meaning that the marijuana found inside the truck cannot be used in trial against Mr. Yuen. If you enjoyed this video, please give it a thumbs up and subscribe to my channel. And if you're listening to the podcast version of this recording on Audible or Spotify, please follow me there and give my podcast a 5-star review rating. And hopefully next time we'll get Carrot Top on this show. Thanks for watching.